Welcome back to this third segment of this English legal system law session relating to the criminal justice process. And just before the break, of course, we're looking at miscarriages of justice. And I started off by saying that you have to look at the process in terms of investigation, trial, and appeal. And I also then ended by looking at appealing from the magistrate's court onto either the Crown Court or the High Court. And I said immediately on the return we would look at appeals from the Crown Court. Well, let's look at that. When you're seeking to appeal as a defendant from the Crown Court, the only route of appeal is to the Court of Appeal. Now, the grounds for appeal prior to the Criminal Court's appeal at 1995 were material irregularity in the course of the trial. That was what it used to be. Now, though, it is if the conviction is unsafe. Is a conviction unsafe where there's reliable evidence of guilt but a procedural irregularity? Well, this of course depends on the approach to unsafe. If you use a broad interpretation, then it would be unsafe. However, if you use the narrow interpretation, it is safe if there's strong evidence of guilt, even though there is an irregularity. The leading case on this, of course, is the Crown and Mullen in 2000, where there was reliable evidence, but there was a procedural irregularity. He had been deported in breach of human rights law and was convicted. Now, getting the defendant to trial in another country had been irregular. When he appealed, he didn't claim his innocence, but appealed due to the irregularity. The conviction, of course, was held unsafe, using a broad interpretation. Now, this kind of approach encourages the prosecution to respect due process rights. Now, what I want you guys to understand now is the linking back together of what we're looking at in respect of miscarriages of justice back to the models and the theories. Now, it removes the incentive to breach the rules. So it doesn't allow, for example, the prosecution to breach the rule in order to get a conviction. This approach, of course, was approved in 2003, another case which also had a procedural irregularity, but the conviction was found unsafe even though the defendant was guilty. Now, the Court of Appeal has been reluctant to interfere with jury verdicts and rather prefer to see its functions as reviewing the conduct of a trial, not rehearing a case. Now, the test used to determine whether to overturn a jury verdict was set out in the case of Crown and Cooper in 1969 as being a subjective question about whether they would be content to let the matter stand as it is, or whether there is some lurking doubt. Now, this has been restrictively interpreted. The Court of Appeal has powers to admit fresh evidence, but rarely does so. When you look at Section 23 of the Criminal Appeals Act 1968, it gives the factors to consider when admitting new evidence. And these factors include credibility, it includes relevance, reasonable explanation for the failure to not have adduced it previously at the trial. And the Court of Appeal, of course, has the power to order a retrial, and this is contained in Section 43 of the Criminal Justice Act 1988. The point here, of course, is that when you look at the unsafe conviction, it does give a wider basis for consideration. Now, there are disadvantages, as if the prosecution knows they can have a second trial, there is not much incentive to do it right the first time. However, if the Court of Appeal didn't have this power, they would be unlikely to quash convictions if they couldn't order a retrial. Now, there are also limitations. The defendant needs to get leave from the judge within 28 days, and time served can be discounted from the final sentence, which is or appears to be somewhat of a deterrent as it relates to appealing. Now then, what is the Criminal Cases Review Commission? You need to have some idea of this. Now, this was a commission set up by the Criminal Appeals Act of 1985, and it followed a recommendation by the Runciman Commission for an independent body who would be charged with reviewing alleged miscarriages of justice and be able to refer the cases back to the Court of Appeal. Now, the criteria is that there must be a real possibility of conviction or that the sentence will be overturned. So the threshold is high. Now, remedies as it relates to police misconduct, trial remedies, meaning that the exclusion of evidence obtained in breach of the rules can, of course, be excluded. The courts are unwilling to do this. However, it tends not to be very effective. There's, of course, complaints procedure, as it is not providing an independent investigation. That's arguably not a very good thing either. There's also the ability for a civil action using the burden of proof. And this is one of the things, of course, that the Stephen Lawrence family availed themselves of, but which, of course, fell apart spectacularly. A civil action against a defendant, the CPS, for example, may refuse the prosecution, as I was saying, a civil action where the defendant has not been prosecuted or the CPS says they haven't got enough, then it may very well be that a private action but may be brought against them. And again, I would suggest that you have a look at the Stephen Lawrence case. It is an interesting case for this area because it starts off with looking at this whole area of miscarriage of justice from the victim's point of view, but then it seems to morph into something else, because then we start looking at miscarriage of justice from the point of view of the defendants. And it is a case that arguably you could get some mileage out of when you're discussing precisely what the law is for and how this miscarriage of justice and due process and crime control work together. However, the person doesn't always want damages. Generally, when you're looking at a civil case, for example, sometimes it simply is that they need to put pressure on, for example, the state actors, for example, for the prosecution or the CPS to get in gear and do something. And again, as I say, this whole area of private prosecutions is one that is of some interest if you read it. Judicial review is where you have a decision that is not in accordance with the legal rules. It usually will be where there is a state agency on the one side and you've got a citizen on the other, and the idea is that the state actor did not act according to the rules. It's all about the procedure. It's not about the substance. However, when you look at things like the Code for Crown Prosecutors, then it gives a lot of discretion. So sometimes in the context of the criminal justice system, it is very difficult to, of course, substantiate judicial review proceedings. Now, if we start to look at the substance, the meat, the cases that have come on board in relation to miscarriage of justice, the problem, of course, with miscarriage of justice is that it really came into sharp focus with the 3 IRA cases of the Guildford 4, the Maguire 7, and the Birmingham 6. Now, in all these cases, the defendants had their convictions quashed by the Court of Appeal, and the government announced the setting up of the Royal Commission on Criminal Justice on the day that the Birmingham 6 were set free. Now, if you look at the structural reforms proposed and accepted by both the May inquiry into the Guildford 4 and the Runciman Commission, which reported in 1993, as well as the establishment of the Criminal Cases Review Commission 1997, we see the state seeking to address these miscarriages of justice which had occurred, and certainly with the intention, no doubt, that something like that ought not to occur in future. Now, although this represents an important structural reform, there are still broader and more troubling questions which have to be asked and answered. So when you look at the policing, for example, should that be considered first and foremost? Is it the courts that had made the error? Do we start from the point of the investigation? Is it the prosecution? Where should one start? Well, in Andrew Ashworth's text on the criminal justice process, both the 1998 and his 2000 book, he sets up the discussion in terms of whether or not a rule or a model is sufficient to understand the complexity of the system. Ashworth says that legal rules are often regarded as the primary means of preventing errors, but the miscarriage cases show that many errors, both deliberate and accidental, have taken place despite the existence of legal rules and powers that were meant to cover the processes. So when you look, for example, at the Police and Criminal Evidence Act, it sets out certain specific process in the codes which are annexed to the act as to what you are supposed to do in terms of prisoners' rights and so on. What we see, though, is notwithstanding PACE, the Police and Criminal Evidence Act, you still had miscarriages of justice. So the idea is that there are rules which, based on the due process model, were in place, but then we see that these rules are not followed. So the idea is the rule supposed to cut down the errors? But if the rules are there and the errors still exist, then where should we be looking? So he carries on and he said, we need to look for wider solutions. Practical measures, he said, include the need for training, proper adherence, he said, to the codes of practice in the Police and Criminal Evidence Act. But the real operational context is the institutional culture in which the decisions are made. And so when you look, for example, on the classic discussion as to institutional biases and prejudices, look at the Stephen Lawrence inquiry, because remember there, the inquiry said that there was institutionalized racism. The point, of course, was when the police came on the scene, the first question being asked was, what did these black youths do for these white youths to have been running after them? And that, of course, bears out this whole concept of institutionalized racism. So what Ashworth is saying is, look at the institutional culture. Ashworth talks in terms of inculcating an ethical perspective on decision making within the criminal process. Now, to speak in terms of a need for ethical perspective is to acknowledge two important shifts in the culture of the criminal justice that need to be investigated. There may be a move towards a crime control model of policing, which almost sees certain miscarriage of justice as an inbuilt feature of effective policing. Because the idea of the crime control model is that the police kind of arrest first and ask questions later. So when you look at this move, that may be a problem. Now, the other is a broader shift in the structure and shape of British society, which has moved from a model of sort of relative homogeneity and moved to one of an inclusive and multicultural pluralism, meaning look at the culture we live in now. Is it that we need to be able in the criminal justice system to reflect that? And it cannot have gone unnoticed. Even in the recent election in the US, you see that there was this cultural or apparent cultural divide when it comes to certain matters. We see that there was this criticism that the Romney ticket did not really take on board the whole multicultural electorate like the Obama administration did. So it may be something that you can draw in comparison here in the UK, is to say, well, is it that when you look at the culture in respect of how criminal justice is viewed, there needs to be a retraining, as it were. But when you look at it, is that it has intensified the problem of institutionalized racism. Well, what I want us to now consider is the conflict between crime control and due process as we look at the miscarriages of justice cases. And of course, we will pick that up as soon as I return after this short break.